Hello and welcome to the latest installment of HFW Industry Insights, where we speak to leading figures across HFW's core sectors about the key issues facing their business and the wider market. Our guest today is Alexander Fessas, the Secretary General at the ICC International Court of Arbitration. Alexander has been with the ICC for over 14 years and as Secretary General is responsible for its dispute resolution services in Paris, Hong Kong, New York, Sao Paulo, Singapore, and the Abu Dhabi global market. Alexander, welcome. Alexander, could you tell us a bit about the ICC International Court of Arbitration and what your role entails as Secretary General?
With pleasure, and thank you for the question. So the ICC International Court of Arbitration, or the ICC Court as we call it, is an institution that administers arbitrations under the ICC arbitration rules and has been doing so for over a century, since 1923. It is, I think, identified for its commitment to service excellence, and it is for that reason that the system of case management operations that it proposes to parties is very much hands-on. So the work, through its work, both the court, the ICC court, and the Secretariat of the court are very much present day to day in those cases, but it also is very much focused on valid and enforceable results. And so it is for that reason that ICC awards, although they do get attacked with setting aside and opposition to enforcement applications, they more often than not survive them. And in so doing, of course, the ICC court is really following a mission that is much broader, and that is a mission to ensure access to justice and the rule of law. And in so doing, of course, it complements the global ICC mission, which is to make business work every day, everywhere, and for everyone. And within that fascinating universe, my role as the Secretary General of the court is to lead the Secretariat's 13 case management teams across 6 different offices worldwide in supporting the day-to-day work of the court, in that our legal staff and our administrative staff take care of party requests, tribunal requests, and requests of the court towards tribunals and parties in order to ensure fair and efficient processes. But I do have a dual role. I'm not only the Secretary General of the court, I'm also the Director of ICC's Dispute Resolution Services. And so in that regard, I am responsible for the creation and the execution of the strategy and work plans with regard to dispute settlement under the ICC setting worldwide. I am also responsible for the operational management of the court and the Secretariat. And I also assist with all our other activities beyond case management, including thought leadership, capacity building, learning and education, and so forth. I spent quite a bit of time at our headquarters in Paris, in France. I also spent quite a bit of time traveling across all our other offices worldwide, and I'm also quite a bit on the road as well.
Thank you very much. The ICC recently registered case number 30,000, a really significant milestone. Alexander, tell us, are you seeing any notable shifts either in the number of cases, the types of disputes that are coming through the ICC system?
Thank you for asking this question. It was the case 30,000 was a very important milestone for us, and it really came at the end of last year, so it couldn't have been better. 2025, we now have the early statistics for the year, was, I think, in terms of case generation, our third or even maybe second best year since the creation of the ICC court. And, you know, I tend to approach disputes as part of the business phenomenon, not a pathology of it, but as something that goes hand in hand with business and good business practice sometimes as well. And so the increase of disputes is not in any one way or should be associated with trouble. Again, it is, I think, a healthy manifestation of a working system. Now, we do live in very interesting times, and I won't, of course, hide that geopolitics, along with many other items, are currently very high on our agenda. And it's interesting, of course, as we move further into the year, to keep exploring further the interaction between geopolitics and disputes, primarily commercial disputes. It is telling, since we're meeting now in the end of, now in the beginning of April, so we have the first quarter of the year over. Unusually, I think we have seen that an increased generation of cases, including in March of this year. So it will remain to be seen whether those this additional case generation is really associated to something that we are seeing just this year. And again, I'm referring to geopolitics, or whether this is a broader trend. And speaking of broader trends, ICC arbitration has traditionally been very, very strong with certain industries or certain types of economic activity, including infrastructure and construction and energy projects. So last year, as was the case with many of the prior years, those are the two economic activities that actually generated a good number of ICC arbitrations. And then there's a second band of industries, or again, types of transactions, including pharma, specialized technology, insurance and reinsurance, that are equally creating or generating a fair amount of disputes that actually end up before ICC arbitral tribunals.
So a recurring theme for arbitration users is balancing efficiency, cost with due process. What can an institution like the ICC do in terms of improving efficiency without compromising fairness, reliability, enforceability?
Well, I think there are many different things that one can do. And I think the reason why the ICC felt quite empowered to even proceed with more innovative solutions is because of the wealth of cases that it has had the privilege to administer over the years, and therefore the plethora of good practices and perhaps less good practices that one might draw inspiration from. Just a few years back, to address the criticism of delay that was encountered by, and is still, I think, to a certain extent, outside of the ICC world, encountered by ICC tribunals in delay in rendering arbitral awards, the ICC court took a rather bold decision in setting out new practice that, according to which arbitrators that would be delayed in rendering awards beyond, say, a 3-month time limit after the last substantive submission or the main hearing of the case, could face a reduction of their fees. And similarly, arbitrators who would actually be expeditious in that endeavor without compromising the quality of the draft award could actually receive an uplift on their anticipated fees. And what that brought in a very short period of time is a reduction of delay. And so sometimes I think beyond core institutional settings, if you like, the black lettering on the rules themselves, good practice, but I also think institutional rigor can go a long way. So that would be one, perhaps, that really speaks about fighting that fight for furthering the cause for efficiency from within the arbitration process itself. But I think there are other things as well. And the debate for efficiency is not a new one. It has been going on for decades now, and it's a constant. And in many respects, I think it's a very good constant and a very good discussion to keep having. It's always that goal that seems to be eluding us all by just a few inches, or sometimes a bit more. But when we're trying to discuss efficiency in arbitration, I do believe that we also need to consider that arbitration is one tool of many that exists in the toolbox. And so perhaps one thing that we should be considering is when arbitration could be used in a way that would actually allow parties to perhaps reduce the scope of their disputes or narrow the scope of their dispute. So essentially all that is put before an arbitral tribunal, or all that is left for an arbitral tribunal to decide, is really what merits a decision by neutral decision makers. And I think that requires a number of different things. I think that requires probably an acknowledgement from external counsel that their clients may need to also become more knowledgeable about other forms of dispute resolution or dispute avoidance processes, how those tools can actually be used interchangeably or concurrently even with arbitration. And then ultimately, I think for arbitrators to be a little bit more, I think, forthcoming about the use of those tools and their power, again, to narrow disputes as they take on cases. One thing we never really talk about is, or often enough, is the rate of settlement, of withdrawal of arbitration cases. And it's quite telling, again, looking at the ICC statistics, that roughly 1 out of 3 of our cases does not end with a final award. It usually ends by settlement. And those settlements tend to happen sometimes by the time the tribunal is constituted, but also later on. So one wonders whether there is perhaps more to be said about further efficiency gains for the parties, at least, if those matters could actually have been settled earlier.
As an organization, you've invested heavily in digitalization. You've moved the administration into a digital case management platform in respect of new arbitrations. How do you see technology changing the arbitration experience for parties, tribunals, and counsel?
Well, I think more now than ever before, technology and dispute settlement processes, and of course the whole legal industry go hand in hand. Interestingly enough, what we're doing today with digital platforms is not really new. We had launched our very, very first case management platform some decades ago. It was called ICC Netcase, and when I joined ICC, it was still operational. And that was an online case management system, very much revolutionary for its time, even if it was ultimately short-lived. So towards the end of the pandemic, we launched our newer case management platform, and as of last year, the even newest one. There are many, many reasons for which the ability to digitalize case management processes and the ability to actually serve a party and tribunal needs through digitalized processes is becoming clearer and clearer and more important. What is also becoming important, and this is something that we discovered last year through a survey that we conducted with the help of Ernst & Young, is that across the dispute resolution spectrum, and regardless of the institutional setting, it seems that no institution is doing a fantastic job when it comes to case management platforms. And that is good feedback. That is feedback that we needed actually in order to get better and in order to ensure that whatever offering we have now we make now available to parties and arbitrators will keep improving, which is exactly what we do. We, as I mentioned, launched a new case management platform last year which is powered by Opus 2. And we're in a partnership with them, and that is indeed bettering and developing. But beyond digital platforms, which are really fantastic tools, I suppose your question also goes to the use of more specialist tech and, of course, artificial intelligence. And there, we have taken the approach of being quite transparent in that today we are not using AI-assisted processes or AI, artificial intelligence at all in our case management processes. And that once we decide to action solutions and to start using AI solutions in support of our case management processes, we will, of course, inform the parties and be quite transparent about that, as we have been with everything else. And without perhaps spilling too many beans, there is a lot of work that is being done internally right now to gear up to that moment. Our first obvious, I think, efficiency gain will be automation of non-case management practices or processes on the day-to-day, and then the automation of certain administrative tasks of the Secretariat of the Court. and then perhaps the development, the further development of AI-led solutions that could even lead to new services and products that are not available today.
Alexander, a distinguishing feature of the ICC is its role in maintaining quality control. That includes the scrutiny of awards under the ICC framework. From the standpoint of parties, does that scrutiny add anything of importance? What is the importance of that approach?
The legitimacy of a process that one builds is of extreme importance in order to ensure that companies, states, and SOEs actually continue using it. And so I would say in that regard that the fact that ICC awards are nearly always voluntarily complied with is a result of the fact that is also a result of the fact that there is this internal review process that is called scrutiny of draft awards, which is basically an exercise whereby the ICC court must review any and all awards in draft form before a tribunal releases them to the parties. And the scope of the exercise is not to second guess the tribunal's decisions on matters of jurisdiction or the merits. The decision of the arbitrators is the decision of the arbitrators. They are the decision makers. It is not the institution. The role, rather, of scrutiny is twofold. It's to ensure, or at least make the best efforts towards a valid and enforceable award, and also to ensure quality of the award. And so most of the comments of the court, which it has discretion to raise, relate to formal aspects of the award, including, of course, reasoning and a number of other things. Whereas exceptionally, the court may also raise points of substance for the tribunal's consideration without, however, affecting its liberty of decision. And I think the reason why, from a user standpoint, this is really important is that scrutiny creates a dialogue between the arbitral tribunal and the court with, again, a very clearly determined scope of action for the court, which is limited, and the opportunity, of course, for the tribunal to liaise with, within a fully confidential setting, with a neutral reviewer, with the aim of having the award become better equipped to withstand setting aside applications, and of course to become better understood by the parties. And so I think it is with that in mind that scrutiny really adds value to the award, and why it matters to those who actually select ICC arbitration.
What do you see, Alexander, as being the biggest challenge facing international arbitration over the next few years? And what do you see as being the biggest opportunity?
I think sometimes one approaches the answer to that first part of your question as arbitration is a panacea or something that should remain going forever. I do believe that the future of arbitration will be assured so long as it, as any other dispute settlement process, manages to respond to concrete needs. And I think it has so far. But that path has not been without its challenges. And I think the current challenges that one faces is some competition also from perhaps more traditional fora of dispute settlement, including state courts around the world that are upping their game, and to a certain extent may even be delivering results that are delivered in much more efficient, time-efficient processes than arbitration. I think many of its key characteristics are now being questioned. Timeliness being one, and the cost, of course, being the other. And I think the other challenge is one that is really looming across the full legal industry, if not, many other professions, and indeed the global economy and trade setting as well, which is the fascinatingly disruptive force of artificial intelligence and what that means for dispute settlement. And I think there will be, what will emerge are many different ways in which parties may actually decide to proceed in order to manage conflict or indeed manage a dispute if one were indeed to arise. So for me, that is a challenge for arbitration, but it may also provide an opportunity for us really to rethink about the priorities in dispute settlement and how or whether we should be focusing on them and how we can actually deliver on them as over the next 10 to 15 years. And then I think also in terms of opportunities, what is really interesting, I think, is that there is more arbitration today than before. There are more arbitral institutions, many more reputable arbitral institutions than before. The practice of international arbitration has increased worldwide. We see that through large structures, global large structures, but also by more flexible, smaller structures regionally and domestically. There is more education on international arbitration and dispute settlement today than ever before. And I think despite the ISDS reform and potential crisis in investor-state arbitration there, I think contract-based arbitration really remains rather strong. So in that regard, I think that we should interpret it as a confirmation of a mission that is still very much top of mind for businesses and states and SOEs as well. So I would think that there is more opportunity for us lying ahead.
And to finish, 3 quick-fire questions, Alexander. What's the most common misconception you encounter about arbitration?
Again, that awards get attacked very frequently. In fact, I think that ICC awards, at least, are, for the most part, voluntarily complied with.
And if you could give counsel and in-house teams a piece of practical advice for running a more efficient arbitration, what would that be?
I think the in-house representatives need to be in the case and on the case from the get-go, including during procedural conferences with the tribunal, case management conferences with the tribunal, and indeed the hearing. And I think they need to be hearing firsthand from the tribunal on its proposals, or sometimes lack of thereof, on how to conduct an efficient process, gradually developing, I think, an appetite of their own as to procedural choices and how to keep the arbitration efficient. I do believe that the role of in-house in a dispute resolution process is still today gravely underutilized.
And lastly, on a rather lighter vein, you're a proud Cypriot. You spent the early part of your career in Athens. Who does the best souvlaki, Greece or Cyprus?
Well, and now you're really putting me on the spot. I think nothing beats a Cypriot souvlaki in terms of a hearty meal. But then again, for someone who may be coming back from a late night out with friends, an Athenian souvlaki is probably the best thing one can have.
Alexander, it has been a real pleasure. Thank you very much indeed for your time.
And thank you very much for yours. It's been a pleasure.